Greetings, everyone, and welcome to the first edition of Alarm Clock. Before we begin, I'll introduce Alarm Clock and what it seeks to accomplish. This is a show that we're going to be using to feature varied panelists, whether politically or not politically involved, to be able to participate in a level of discussion where we could answer questions. It's not a bashing platform, but it's a platform for us to be able to share and to be able to get information.
All right, good evening, everyone. And it seems as though we're having some internet issues with our host. So I will step in for her while she organizes that on her end. I am Jeanne Williams and also one of the members responsible for the alarm clock. If you were just listening, you would have heard Desi begin to explain what the focus of the show is. It's really about bringing people together to discuss politics and governance in St. Kitts and Nevis in a way that is not bashing. It allows persons who are politically affiliated and those who are not politically affiliated to discuss their views. We talk about the issues, not the people. And we think that it's about time that we really elevate that sort of discussion in St. Kitts and Nevis so that we could really talk about issues. And when we really talk about issues, then we start getting solutions that fit as many people as possible. So you're going to be hearing more about alarm clock as time goes by. This is not the panel that will be on the show all the time. That's one of the questions that we have received. We will switch. You may see completely new faces for other episodes depending on the topics that we talk about. So don't feel as though you're going to always see these same 5 faces. You may never see these faces again. We're hoping that we can encourage a lot more people to get into the discussion. Those who are interested in, the issues and politics and governance and not so much of the bashing that we normally associate with our politics. So that's what Alarm Clock is seeking to do. You will hear more about it. So we hope that you sign on to and subscribe to our YouTube channel and our Facebook page so that you're updated as to the next shows, the next topics. And feel free to shout us out and tell us, other topics about politics and governance that you want to hear about. So we'll move right into the show because we just had an address from the Honorable Prime Minister talking about the dissolution of Parliament. And, so tonight we're going to be talking about what does that mean? What's the impact on, for people who may have business to do with government? Does it, cause any major changes? What does that mean for elections? And we're dealing with a pandemic right now. And so we are going to be discussing tonight about the sort of issues that we think will arise coming out of having to have an election in a COVID-19 era. So I'll take this time now and I want to introduce the panelists, the other panelists tonight, and we will go into the discussion. So if we could, our first guest, our first panelist, we're joined by three attorneys. We have Gath Wilkin. He is an attorney attached to Kelsey Wilkin and Ferdinand. We have Mr. Chris R. Freeman, an attorney, Crown Counsel with the Legal Aid Center and Advice Clinic. And we have Mr. Azad Gomes, who is also an attorney. And we are very happy that decided to join us here this evening and tell us a bit about what the topics are, what we're planning to talk about tonight. So going into everything, so guys, we just heard from the Honorable Prime Minister that the Parliament was dissolved as at Tuesday, 12th May. So any reactions? Anybody surprised? Any any sorts of reactions at all? Just kind of figured, well, we all know it was coming, so it was, I guess these guys are like so ready to get into the discussion. But so what does it mean? What does dissolution of parliament mean? What is the impact? So I would just mention at this juncture that the dissolution of parliament, for those of us who may not be so familiar with parliamentary procedure and what is happening, it is the official end of the parliament, of the term of the parliament. It is constitutionally based, so it's not a matter of, you could just get up and decide to do it today or not to do it tomorrow, but it has to be something that is in line with the Constitution. And that is what we saw tonight. So the term of the parliament has come to an end. The 5 years from the first sitting of parliament, which would have been May 14th, 2020. And so we have now reached the maximum time that a parliament's life could extend. So now it has come to an end. So that means essentially that all of the seats of parliament are now vacant. So there is no longer a member of number 3 or a member of number 7. They're all vacant seats now. And so the impact of that is that they're all now gearing up to go into election mode. And so we're going to be hearing more about ringing the bell, nomination day, and all of that. And hopefully tonight we're going to go into that discussion about, what do we see coming out of this pandemic? How is that going to impact us with elections? So that's what dissolution of parliament means. The term of the parliament has come to an end. All of the seats of parliament are now vacant. However, we still have a cabinet, so don't feel like we don't have a prime minister or a minister of foreign affairs or something like that. We still have a cabinet, so they will still be responsible for running the country, but the seats are vacant, and now everybody is going to be full on in campaign mode. Desi, I see you're back. Or yes, and just to say thanks as well to all the people who sent questions prior to the show tonight. We do have quite a bit of questions, and we're going to try and answer as many of them during the discussion, or we will take pauses to answer the questions as well. So, Desi, do we have any questions relating to dissolution? Is there anything anybody wanted to know?
At this time, no. I think most of the cyber questions we got were questions generally about what the dissolution is and what the impact would be on St. Kitts and Nevis. Currently, we can move forward with the discussion. I think it seems as though everyone is on board. So as we move forward, we wanted to look at election day. Now, what does it mean now? What could we expect and the process? We'll invite Prios to speak on this topic.
Thank you very much, Desi, for that introduction, and thank you very much for considering me sufficiently qualified to be a part of this conversation. I am, because despite my obvious political affiliations, you and Gian, who both conceptualized this program, felt I could be mature enough to take part in an exercise that is intended to educate the populace here in St. Kitts and Nevis without the need to become partisan and doggedly political. I want to say a very special good night to all our listeners on Facebook and YouTube. It is a privilege that I respect and appreciate that you have tuned into this conversation and allowed us into your living rooms and your homes. My colleague panelist, Ms. Williams, has just given you a brief overview of what dissolution of parliament is. And I have the opportunity to further that conversation. And so I say, Parliament has now been dissolved. We may not have heard the alarm clock on Tuesday when Parliament was dissolved, but we were informed tonight nevertheless. And usually on the dissolution of Parliament, what comes next really depends on whether an election date is given on that dissolution. Tonight we were informed, or really there was no election date that was identified. And so from the point of a dissolution of Parliament to the holding of elections, according to the Constitution, this must all happen within a 90-day period. So elections must be held by August 10th, if it is from yesterday. And whenever elections are announced, there must be a lapse of at minimum 17 days between the announcement of the election and the polling of the elections. What triggers an election? An election is usually triggered by the issue of writs for holding that election. The Governor General shall issue writs under the public seal of the state.
All right, and we're back. We seem to be having a bit of technical difficulties, but we'll try to move forward and tread through so that we can get back to everyone else and address the topics that we had covered for this evening. So we're going to go over to Gaff, and we're going to speak to Gaff on boundaries and the review of the Privy Council's decision. And what about the Boundaries Commission? So we're going to have Gaff speak to us on that.
Yes, Desi and Gian, thank you for inviting me to the program. Just making sure that you can hear me. We're having some technical difficulties, but that usually happens when you do something for the first time. But I think it's a very good idea to have this program so that we can discuss issues and not people. I think that's important for the development of our country, and I'm glad I can be part of it. Good evening to everyone who is listening, and I hope I can bring something to the table. I will be discussing constituency boundaries, and the number one question that everyone has is, what will be the boundaries for the next election? So hopefully at the end of my presentation, we'll have a clearer view. There is no answer, I'll tell you that right now. But after I say what I have to say, let's have a nice discussion and get the different views on what actually pertains right now in St. Kitts and Nevis. Just to set the background a little bit about boundaries. In our Constitution, it's required that a Constituency Boundaries Commission be appointed during the life of every government. The life of the government really is from the date of swearing in of the government to the next dissolution of Parliament. So technically, as the Prime Minister indicated tonight, the end of the government was effectively at the dissolution of Parliament. Not that the government doesn't continue to function, but in terms of the parliamentary term of the government, it is now over. So during every life of a government, a constituency boundaries commission is supposed to be appointed. And that commission is supposed to consist of a chairperson appointed by the Governor General, acting in accordance with the advice of the Prime Minister, given after the Governor General has consulted the Leader of the Opposition and such other persons as the Governor General, acting in his or her own deliberate judgment, has seen fit to consult. So in essence, the chairman or chairwoman is someone that the Governor General chooses after consultation with both sides, the Prime Minister and the Leader of the Opposition, and any other person the Governor General chooses to consult with. Two members are members of Parliament appointed by the Governor General but on the advice of the Prime Minister, and then the other two are members of Parliament who are appointed on the advice of the Leader of the Opposition. So in essence, the ruling party gets two choices, the opposition gets two choices, and the Governor General is supposed to appoint quote-unquote independent chairman or chairwoman to the commission. The commission is required to review the number and boundaries of the constituencies into which St. Kitts and Nevis are divided and submit to the Governor General reports, either one, showing the constituencies into which it recommends that St. Kitts and Nevis should be divided, or two, stating that in its opinion, no alteration is required to the existing number or boundaries of the constituencies. So effectively, the commission can say, listen, we have decided that the boundaries, the number of constituencies should be X, and the boundary should be Y, and this is how we propose to change those things. Here's the report, Governor General. Or they can say, everything is fine, there's no need to change the boundaries or the number of constituencies. But what must happen is that when the commission is considering the division of constituencies, they must ensure that there are not less than 8 constituencies in St. Kitts and not less than 3 constituencies in Nevis. And if the number of constituencies is increased beyond 11, that's 8 plus 3, not less than 1/3 of their number shall be in Nevis. So really, we can have more than 11 constituencies, but the balance is required such that Nevis must have at least 1/3 of the number. All constituencies shall contain nearly equal numbers of inhabitants, as appears to the Commission to be reasonably practicable, but take into account the following factors: the differences in density of the populations in the respective islands, the need to ensure adequate representation of sparsely populated rural areas, the means of communication, geographical features, and existing administrative boundaries. So all of that needs to be thrown into the pot, and the commission is to look at all of that information. But I think the fundamental one is that we are a society where it's supposed to be one man, one vote. So the primary consideration really should be that there be as equal amount of numbers in each constituency as possible and is fair, take into consideration those other factors. And the Constitution requires that the Commission is to submit reports at intervals not less than 2 nor more than 5 years in the life of every government. And submission of the report to the Governor General is mandatory. In other words, the Constitution contemplates the establishment of the Commission works, and the Commission submits its report, or it says to the Governor General, there is no need for a change at this time. So that's mandatory. As soon as the report is submitted to the Governor General, the Prime Minister is required to lay the report by way of a draft proclamation to Parliament. And the Prime Minister can then make modifications or present it as it is presented by the Commission. And if the Prime Minister makes modifications, he or she has to justify the modifications, and then the National Assembly, which is the Parliament, votes on the report. So it goes through various stages before boundaries are actually changed. And the most important thing I'm going to say in terms of boundaries is this statement from the Constitution. If the report, or whatever report is accepted by Parliament, the proclamation shall come into force upon the next dissolution of Parliament after it is made. And I want to repeat that because it's very important. I want to stick a pin in that, which we'll get back to later. The proclamation, which is in essence the declaration of change in either the number or the thing of boundaries, shall come into force upon the next dissolution of Parliament after it is made. Now, the question of validity of any proclamation by the Governor General shall not be inquired into by any court except upon the ground that the proclamation does not give effect to the 8 minimum in St. Kitts and the 3 minimum in Nevis. Otherwise, the two-thirds rule. So in other words, once the proclamation is made, a court cannot look into its validity unless it has to do with a miscalculation, for example, that the two-thirds rule is not kept. Every government really is required to seat a commission. The commission is supposed to submit the report after 2 years, and the Prime Minister is supposed to put the proclamation before Parliament for approval. That is what the Constitution requires. Now, that is just to set the scene as to what the Constitution says about boundaries. Now let's go to the famous Privy Council case of 2015. And I will be doing a lot of quoting from the case because I could never put it as good as the judges have in that case. But in essence, what happens is in St. Kitts and Nevis, we face the problem that since 1989, 31 years ago, there has been no updating of the constituencies. So there has been no effective change in the boundaries since 1989. The Commonwealth Assessment Team in 2005, the Commonwealth Expert Team in 2004, and again in 2010, expressed concerns that a review was overdue. The case that went before the Privy Council, therefore, arose out of an attempt by the Denzel Douglas-led government to break that impasse on January 16, 2015, when that government sought to change the boundaries immediately before an election. I will call the boundaries that were determined in 2015 as the 2015 boundaries, and that is the report that would have been submitted by the commission that was established between 2010 and 2015 by the then government. Now, the actions of January 16, 2015 were challenged in court, and eventually the Privy Council, our highest court of appeal sitting in England, decided on February 11, 2015, 5 days before the last election, that the dissolution of Parliament occurred before the Governor General's proclamation was made. That is very important. As I pointed out to you, the proclamation comes into force upon the next dissolution of Parliament after it is made. So if the dissolution of Parliament occurs if the dissolution of Parliament occurs prior to the proclamation, then clearly that dissolution is not the next dissolution. So that was the essence of the ruling. And the Privy Council ordered that the elections be held on the 1989 boundaries, not the 2015 boundaries. But that's not the end of the story. In essence, the proclamation that in relation to 2015 boundaries was made on January 20, 2015. It was signed on January 16, 2015. But because the effective date of the proclamation was after the dissolution on 16 January, the 2015 boundaries did not come into force for the last election. So I want you to remember in this context we're discussing, and the question really is a very interesting question of law as to whether we will be going to the next election, which is due within the next 90 days or 89 days, on the 1989 boundaries or the 2015 boundaries. In summary of the Privy Council decision, in essence, the Privy Council said, listen, when the Constitution provides a mechanism by which laws and proclamations come into force. Laws and proclamations come into force only when they are published in the Gazette, meaning that every single person in St. Kitts has the opportunity to obtain a copy of that law or proclamation, so that it doesn't sit down in a government office and there's a law that the public does not know about. So that was the essence of the point about when the actual proclamation became effective and was made. And without going into too many details about the case, because at the end of the day, the case before the Privy Council was really only in relation to an injunction that was granted by the High Court judge at the time on the evening of January 16th, which prevented, in essence, the use or the proclamation of the new boundaries based on the report from the 2010 to 2015 Commission. So, this is what happened. There was a commission established by the previous government, the 2010 to 2015 government. On January 16th, that government went into Parliament and they tabled the report, in essence, by way of the proclamation. It was passed. And upon it being passed, Parliament was dissolved, all on the same evening, January 16th. Effectively, what I assume what they thought was that the proclamation was passed, then Parliament was dissolved, so the next election would be based on the 2015 boundaries. What happened in law and what the Privy Council found is that the reverse happened, which was dissolution happened, and then the proclamation became law. So what we are faced with right now is that the injunction that was granted on the evening of January 16, 2015, remains in force. It means that a court has said that the report or the proclamation cannot become law. When the Privy Council was dealing with this issue, they specifically said, listen, we have only been asked to determine what is the effect of the injunction, and we are not asked to decide the substantive matter as to whether the 2015 report is valid or not. So that is still open. The validity of the 2015 report is still open for determination. As far as I'm aware, there has been no change in the status of that case. And the injunction that was granted on January 16, 2015 remains in force. Now, the other question that arises is, if that injunction is removed, because technically someone who is a party in the proceedings could simply say to the court, listen, a case was initiated in 2015, nothing has happened with it. There was an injunction granted. We want that injunction to be removed. And the question then becomes, if that injunction is removed, what boundaries are in force given the dissolution of Parliament 2 days ago? That is the difficult question, because the language of the Constitution is such that it says that if the proclamation comes into force on the next dissolution of Parliament, just from a date perspective alone, January 16, 2015 was the last dissolution. January 20th, 2015 was the effective date of the proclamation. And now on May 12, 2020, there has been the next dissolution of Parliament. So, unfortunately, because the case, which was, I believe the actual claimants in the case were Mark Brantley, Dr. Timothy Harris, Sam Conda, and Sean Richards, which is strange, which becomes strange because they were the ones who were challenging, and now they are the government. So the Privy Council even recognized that their case may never reach anywhere because they would in essence be fighting against themselves. However, the non-prosecution of the case has robbed us of an opportunity to answer some very important constitutional questions. So, with all that said, I'm going to ask the question because there's no definitive answer. Given the time frame, January 16th, last dissolution, January 20th, 2015, proclamation passed, injunction granted, injunction still in force, and a dissolution on May 19th, 2020, what really are the boundaries that we are supposed to have the next election on? The validity of the proclamation of the 2015 boundaries is still open. There's been no determination about that. And the injunction remains in force. So we will be seeing, I assume, over the next few days or weeks, the position that either of the political sides will be taking in relation to that case. They could very well say, listen, everybody has prepared based on the 1989 boundaries, and we're going to have the election on those boundaries. Or somebody could get smart and say, listen, the 2015 boundaries are the boundaries that are now in force because the next dissolution has happened, and the proclamation was after the previous dissolution and before this dissolution, so therefore they are the new boundaries. The Privy Council in the decision that it would, whilst they weren't dealing with the substantive matter, that matter would help to determine what are the boundaries for the next election. There was a new constitution and a new constituency boundary commission established in this government, which is 2015 now to 2020. But as far as I'm aware, they have not submitted a report, and they can no longer submit a report because on the dissolution of Parliament, all of the commissioners vacate their position. So that is open for debate. The reason why I try to bring the history and the constitutional context is so that it can help people to develop their own arguments, whether you're a lawyer or not, because constitutional issues are not issues just for lawyers, but for everyone's concern, for everyone to digest and think about it and determine for themselves what they believe to be the applicable boundaries. It is definitely up for debate. However, if the injunction remains in place, then technically it's not up for debate because the injunction really froze the time in terms of that 2015 boundary report at January 16, 2015, as if the proclamation on January 20th was never made. So the debate arises if the injunction is removed. And of course, any matters like this, as we realize, take a while to get through the judicial process, and is not a willful neglect by the judicial process. It's a timely process. You have to make arguments, you have to submit documents, especially in a time like this where the court is in a virtual mode. It's going to be very difficult to get to a full resolution of this issue. And I think it should have been done during the last 5 years, but for whatever reason, political or otherwise, it was not done. Maybe both sides who were party, because Dr. Douglas was a party in the matter, Dr. Harris was a party in the matter, any of those parties could have sought to move the matter along so that we wouldn't have these questions still lingering, these constitutional questions still lingering. So given what I have said there, I'm welcoming any questions or comments. As I said, my personal view, and lawyers differ. I'm sure Gian might have a different view on it. is that once the injunction remains in place and is still in place, then we're dealing with 1989. If the injunction is removed, then we have a serious debate on our hands.
Okay, well, Gath, you actually have some questions, so I'm gonna read some of them to you. Someone wants to know who will have to validate the injunction, the Privy Council or our local court? Any response to that?
I'm not sure. The original injunction by the High Court
I think
judge was made
maybe
on.
she's referring to the removal, maybe? Who will have to remove it? But I don't think, which court would you have
Yes,
to?
it would be the High Court. The
Okay.
High Court, which is seized of the substantive matter, would have to be the court that is moved if anything is to be done by the injunction, because the injunction was granted by the High Court. However, it was confirmed by the Privy Council, but the High Court can still deal with it however it may choose to.
So it's not a situation where we have to go back to the Privy Council to handle that. There's another question. Gath, there was an injunction against, well, I think this probably came early, but I'll read it still, just in case you want to reinforce anything. There was an injunction against the 2015 boundaries. Has anyone filed in the court to remove that injunction? If the injunction is lifted, then does that mean that the 2015 boundaries can then be properly gazetted? I think you responded to that, but just in case, I'm not sure where this question came. So. Yeah. Any further?
I was just going to say that that's in essence. I hope I made it clear. I know some might find these constitutional legal issues a bit dull, and I'm not the most exciting person in the world, but I hope people understood the timeline and the implications.
Okay.
But Gian, before I go, I just want to say that, these sorts of issues should never arise, because that case should have been prosecuted by either side. There's no particular side you can give blame to, but we were shorted by that matter not actually reaching to an end, a conclusion.
Okay. There's another question. I'm asking if a commission was appointed during this government and what were their findings. Don't know if you know that answer.
I did hear Congress Maynard on the radio yesterday saying that he's part of the commission and they did meet. But as far as I'm aware, I don't think there was any report submitted to the Governor General.
Okay. But there was, if I could
go ahead, Chris.
Provide a little. Yes, there was in fact a commission that was put in place. It had a chairman who resigned and was replaced. I think the latest chairman would have been Denzel Cook. And you had from the government side the Honorable Ian Patches Liebert and the Honorable Vance Amry, and from the opposition benches you had the Honorable Congress Maynard and the Honorable Patrice Nisbet. There was no report submitted, and I don't think that all the meetings were held, there were anything of any substance that has come from the meetings of that commission.
Okay. All right. Well, Gath, that was quite the summary. Hopefully people are a bit wiser about this. Chris, it seems like you're back up. So Gav has basically told us that we don't know which boundaries, but it is likely the 1989 boundaries that the next elections will be on. Did I quote you right, Gab?
Yes, it's safe to say that it's more than likely that the next election will be on the 1989 boundaries for other reasons as well. Because in the Privy Council's decision, they also said that there's a strong case that there was a breach of the due process constitutional rights by the claimants, which would make the proclamation null and void. And also there is a strong case that it could be found to be unlawful. So the only issue would be if a judge potentially could say, listen, you didn't prosecute your case, so you can't have an injunction that lasts forever. So I'm going to remove the injunction and we could go ahead with this case. There is where I think the uncertainty arises if the injunction was actually removed.
I think though that some resolution to this matter might be worthwhile. I mean, the decision in the motion of no confidence matter came late, came after it was of no moment. But I think that we are still a young country, and for our jurisprudential development, it might be worthwhile to have some clarity on this matter, because the issue of boundaries have been in court since around 2009, not just the last election. And it one were to be rational and fair-minded, we would have to think that it is kind of unfair to a candidate in constituency 8 to have to serve so many individuals after he's elected, in comparison to the person who wins the election in constituency 5, for example, that is just Sandy Point and Victory and La Valley. So even if both parties, both sides are not interested in the matter, I think at least some citizen of the country, because we are all affected by whether or not the boundaries change or remain the same, that some private citizen might be able to get standing in the matter and prosecute the matter to completion, whether before election or if the judgment comes after election.
From a non-partisan perspective, that I this month I've been back home for 10 years, and I can tell you in that 10 years that the amount of migration that has happened, for example in the Shadwell area, that the boundaries are not fair. The 1989 boundaries was a totally different St. Kitts, and curious, we've had these debates since UE days, but I think we make too many decisions because of partisan political issues. Like each side thinks that the other side is going to gerrymander the boundaries. I mean, that is clear. Let's be honest. But why can't both sides come and say, listen, 1989, that's a bit long. Let us have a commission. Let us have an independent chair. Let us put the persons on there and tell them, listen, just be fair. Let us get the boundaries sorted out, and let's just level the playing field, and we go from there. Because the average, I was looking up the numbers, the average registered voters per constituency, when you look at all of the registered voters for the last election, is 3,835. But you have some constituencies with 1,300. You have constituency number 8 with 5,753. So how can that be reasonable? How can that be reasonable in a constitutional context where we are a one man, one vote democracy. So, Krios, I hope because you have sway in your party, I hope that you will tell them, no matter who wins or who's in opposition in the next election, we should all come together on this issue because we need to mature. And I think it's immaturity, political immaturity, that has caused us to not have new boundaries for 31 years. Come on. And that's by both sides.
Yes. Well, thanks, Gab. But I think we have exhausted the boundaries issue. I guess we'll have to wait and see what happens. But regardless of what's coming, in terms of boundaries, we have elections to deal with. We're in a pandemic. Azad, are you there? Azad, it has been quiet so far. I don't know if we could go into the elections part of it because we have about 30 minutes left. So we're in a state of emergency. Azad, we had a question relating to like state of emergency and so on. Like, can you just give like a brief, very, very brief presentation in terms of the state of emergency and how that is going to impact the elections coming up? Azad, I don't know if you can hear me. Your mic. Your mic. Okay, well, while we wait for Azad, in terms of elections coming, Chris, I don't know if there's any consideration you think. Like, what do you think we're going to have to do to deal with in elections in COVID-19 era?
I've scrolled through the National Assembly Elections Act, Jian, and it appears to me that the only thing that might be possible now is that polls can be open for longer because the writ can state the time period which the polls are open. Of course, we know how long it takes when you go to the supermarket or when you go to the drugstore, so that is going to have to be a consideration when considering an election under a state of emergency. I don't think so. Election must be held by August 10th, and I'm almost certain by then we would still be wearing masks. We will still be asked to social distance and stay 6 feet from each other. So individuals will have to take a longer period in the lines, and you do not want lines to be as bundled as they might have been in the past. Anything else, Gian? And this is the perplexing question now. Anything else would certainly have to come with changes in the legislation, the National Assembly Elections Act, or its regulations. As we know, Parliament has been dissolved, but the Parliament can be convened for certain important matters. I don't know if these matters would be considered to meet the constitutional threshold to go back and reconvene Parliament to make the changes. But you know, the conversations I've been hearing on the street People are wondering if locals can vote by mailing their ballots in or electronically. But as of this moment, there is no provision whatsoever for voting except by showing up to your polling station on election day and casting your ballot. So these are exciting times ahead, uh, because we will have to see how over the next 89 days things play out in ensuring that we have an election which respects um, um, the rule of law and the democratic country that we reside in, but which considers the grave public health issue that is confronting us.
I agree with you in terms of there have to be changes made, because when you look at the National Assembly's Act, yes, it really assumes that we're all going to go to polling stations and line up, and you have to cast your ballot. The regulations are